call on Deputy Ó Laoghaire. There's a total of 4.
Cormagat and Cian Corley, I understand leave has been given to dedicate some time to Deputy Doherty. Firstly, I want to say I'm really very disappointed that there isn't a minister here from the Department of Justice, given the significance of this issue for hundreds of families, given the implications it could have, given the fact that it could lead, I believe, to people being put out of their homes. Minister, there's a phrase called equality of arms, which is used in the context of court cases occasionally. It is a central part of a fair trial, that there would be a fair balance between the opportunities afforded to the parties involved in litigation. Minister, that has been absolutely destroyed for families in insolvency applications who may be facing repossession of their homes by the changes to the legal aids rules brought in last Friday. They will make it much easier for banks and for vultures to repossess homes, and I believe that people will be left completely to the wolves. Up until now, if you were applying for a personal insolvency or appealing the refusal of the banks to grant one after the veto was removed, then you could avail of the advice of a solicitor and a barrister. As of last Friday, the government has removed the right to a barrister for the debtor in court, other than in exceptional circumstances, and halved the fees for solicitors and personal insolvency practitioners. I would ask you to bear in mind first, Minister, that these are people who are potentially, if they're not granted a personal insolvency arrangement, could be on the verge of losing their home. They are people that, by definition, cannot afford their own legal representation. On the other hand, they are taking on banks who will have the very best of legal representation available and dealing with very complex legislation. The banks will spend 5,000 to 10,000 on each interlocking case, and even where, in the exceptional circumstances that a barrister is given, and it is exceptional circumstances, the fee of 1,200 was loss-making and won't get you any barrister to take that case. Now, I want to give an example, Minister, briefly before I pause. Just yesterday, a case was decided in the case of Miss Lisa Parkin, where the judge approved a personal insolvency arrangement and accepted that the bank had entered the case making a different argument than they ended up relying upon. Had Ms Parkin not had a barrister capable of responding to the bank that was changing the goalpost within the case, there is every likelihood that she would have lost and potentially lost her home. Add to that countless more cases that could mean people being out on the street. Minister, this is an attempt to disarm the debtor who may well be fighting repossession.
I must say, Minister, this is an absolute scandal, and indeed what it is, and we need to call a spade, this is an attack on vulnerable people, people who find themselves insolvent, people who are going through the insolvency process, people where a PIP has suggested a restructure of their arrangements and where in the main the bank has blocked that. And now what the government has done is to restrict the fees available, so in order that those individuals will not be able to enlist the services of a barrister to fight the banks who are trying to block the PIP's arrangement. And what we see when actually these do go before courts in terms of the Section 115A reviews, 65% of debtors are actually successful. They actually beat the banks. And that is obviously, I think, probably the core of this here, because we know that the government is in the pockets of the banks. The government is on the side of the banks, and the government is always against the debtors that are struggling, and we see that through a number of initiatives that this government has brought in. But this is scandalous, Minister, and this needs to be reversed. We need a level playing field. We cannot have it where the banks march in with their teams of barristers and solicitors and allow a vulnerable debtor, which, as I said, in the main, win in these cases in the court, to be left in a vulnerable position. So I call on you, even at this late stage, to reverse this decision and make sure that there is an equality of representation when it comes to our courts.
Minister's 4 minutes.
I'd like to acknowledge and thank the deputies for raising this issue. And I would like to say that the Legal Aid Board recently notified some changes to the professional fees payable to lawyers and personal insolvency practitioners, PIPs as they are known, in cases that are legally aided under Avalia. I should emphasise these measures do not reduce the protections that are afforded to borrowers under Avalia, as has been claimed by the Deputy. Under Section 115A of the Personal Insolvency Act, if creditors refuse a reasonable personal insolvency proposal by a borrower to resolve his or her mortgage arrears, the borrower's PIP can apply to the court for review. The court has power to impose the proposal on creditors if satisfied that if it is fair and reasonable to all parties. Where legal aid is approved for a court review under Awalya, the Legal Aid Board pays set fees to PIP, the solicitor, the junior counsel, where needed, the senior counsel representing the borrower. Under Awalya, the Legal Aid Board has already approved legal aid for over 1,000 court review applications. 64% of these were decided in favour of the borrower in the year ending June 2018. 2 reasonable changes have been introduced to the fees for all professionals. Firstly, the full fee will not be payable in undefended cases, where no creditor opposes the court review. Secondly, personal insolvency cases often involve parallel applications by both partners. Where a couple has the same home mortgage, in practice, the vast majority of parallel applications are treated by the courts as one single case. There is no reason for taxpayers to cover 2 full fees in such cases, and they will be payable at a full fee for one spouse and reduced 10% fee for the second spouse, representing the actual extra work involved. There is no change to the legal aid fees payable to the PIP and the solicitor for a defended personal insolvency court review. Barristers' fixed fees are being reduced, but only to bring them into line with fees payable to them in other areas of the civil legal aid where complex legal or procedural issues arise. It is not correct that borrowers will be left without barristers to argue their case. Barristers will not be approved automatically in undefended cases. For example, there may be no need for a barrister, but the Legal Aid Board has expressly underlined that counsel will be approved where a creditor is raising legal issues that need to be argued by a barrister or in exceptional circumstances.
1 minute, Deputy.
The Minister has attempted to outline that there is no changes, but clearly, when you look into the text and into the detail of it, there's significant changes. The specific example I gave, which was on the basis of husband and wife's case, on interlocking cases, where the reality is that banks will spend 5,000 to 10,000, and what is now being allowed, even in those exceptional circumstances where you can get a barrister, is 1,200. That is not going to be enough to pay for a barrister. Nobody's going to take that job, given the complexity of what's involved. Just to give you an insight into the complexity that is involved. Section 115s are complex. The brief would run from 300 to 500 pages, 4 or 5 affidavits and substantial exhibits. There's a substantial body of jurisprudence. You cannot expect a solicitor to do this on its own, and it should not be in only exceptional cases. This should be as of right, and this needs to be reversed, Minister.
Look, Yaskin Corley, the long and the short of this here is the government have moved in to cut the amount of support that is available for struggling homeowners in a case where a bank or a vulture fund is blocking a PIP arrangement. And you've done it in a way that no barrister is going to take instructions from a solicitor knowing that the maximum amount that's payable to them is €1,200, because they know, and they see it in the courts, that the banks and the vultures are losing these cases on the basis of the numbers and embraces of the figures. So what the banks and vultures are doing now is raising legal technical issues, and you will not be represented for that. So what you're doing, Minister, and what your government is doing, and it is absolutely no surprise, is you're throwing these debtors to the vultures, literally. It is not acceptable. You talk about that the principle of this government is to keep families in their home at all occasions where possible. This is exactly the reverse of that. This is basically taking away the safety net that they have, which is legal representation, to fight the army of solicitors and barristers that walk in with the banks and the vulture funds into the courts when they know that they're on the wrong side of the argument, as has been proven in the past, where 65% of the cases have been won in favour of the borrower and have been able to remain in their home. So there is no reason for this to be cancelled. And I'll finally make this point. This comes in the same week as the government was proclaiming the success of Abhaile, and then within a number of days what they do is they pull the safety net out from those using the Abhaile service, and you're seriously undermining this service as a result of it.
Minister has 2 minutes for a concluding statement.
Thank you very much. I acknowledge the Deputy's concerns, and to ensure that the protections available under Abhaile remain in place. And once again, I must emphasise that these changes do not undermine the free legal protection afforded to borrowers under Abhaile. Borrowers can still access full financial and legal aid services and help, including legal aid for personal insolvency court review, without any charge. The Minister has already outlined, launching the recent Abhaile reports, the priority that he attaches to the good work being done under Abhaile, and to ensure that the personal insolvency review will function effectively. And it is emphatically not the case that borrowers will be left without a barrister to argue their case. And indeed, most will benefit from personal insolvency or PIP, a solicitor, a junior counsel, and wherever needed, a senior counsel. The Legal Aid Board expressly indicates that counsel will be approved if a creditor is raising legal points which need to be argued by a barrister. The question was raised by Abhaile does not also provide legal aid for contesting repossession proceedings. This criticism misses the point. Abhaile does not focus on contesting repossession proceedings because in most cases that will not help the borrower. As the lender still has an enforceable mortgage contract, it can reissue repossession proceedings as long as there are mortgage arrears. Instead, Abhaile focuses on getting into a place and integrate a solution to the arrears themselves, so the borrower can remain in their home and return to solvency. This is far more effective focus for public intervention, better for borrowers and better for the taxpayer. Meanwhile, Abhaile provides court mentors and duty solicitors to assist in ensuring that the repossession proceedings can be adjourned while the borrower is working with Abhaile to get a solution in place. And in conclusion, Laskin Corla, I do not accept the assertions of the deputies opposite, saying that we're throwing these people to the vultures. I know in my own constituency in Wexford the important work that Abhaile has done, and they will continue to do going into the future.
We now move on to private members. And